Hello everyone. Let's discuss today's The Hindu editorial page. The first article is AI and the issue of human centricity in copyright law. In this article, the writer says that the executive order in the United States, issued by the Biden administration on October 30th, highlights the changing attitude of global leaders towards AI regulation. The implementation and use of AI without the necessary safeguards can have enormous implications for the future of humanity. And the changes in regulatory approaches are a welcome development. One area where AI has raised tough questions is ownership and enforcement of intellectual property, IP rights. For example, while generative AI tools such as ChatGPT and Midjourney allow people with minimal creative skills to produce reasonably beautiful outputs with the help of a couple of text prompts, their use has raised several copyright-related questions. These include whether the use of copyrighted materials, including texts and images, as training data infringes the rights of millions of authors and artists on the internet. A recent decision of the United States District Court for the District of Columbia in Stephen Thaler v. Shirley Perlmutter provides some insights on whether copyright can exist in work autonomously created by AI. In this case, Mr. Thaler owned an AI system named Creativity Machine, which he claimed had autonomously created a piece of visual art. The Copyright Office rejected the application on the ground that the submitted work lacked human authorship. He challenged the rejection before the district court, and the court concluded that human creativity was essential to copyright protection. The court's line of reasoning is in tune with the general position of the U.S. Copyright Office, which has stated that copyright can protect only material that is the product of human creativity. The term author, used in both the Constitution and the Copyright Act, excludes non-humans. The court also clarified that copyright applicants had a duty to disclose the inclusion of AI-generated content in any application, followed by detailed guidelines on doing so in registration forms. Recently, it initiated a public consultation on various copyright-related questions posed by AI. In India, the Indian Copyright Office registered a work of art called Suryast in 2020, for which an AI system named Raghav Artificial Intelligence Painting App was listed as a co-author. The Copyright Office had previously rejected an application in which the same system had been listed as the sole author. While India has not experienced legislative changes in the Copyright Act 1957, the increasing use of AI and its potential impact on the future of humankind is a welcome development. The next article is Impacting a Woman's Freedom to Reproductive Choices. In this article, the writer says that in X versus Union of India, the Supreme Court of India declined permission to terminate a 26-week pregnancy for a woman who was seeking it. The court held that the case fell outside the scope of the Medical Termination of Pregnancy (MTP) Act 1971, which permits termination of pregnancy beyond 24 weeks only in cases where the fetus exhibited substantial abnormality or where the woman's life was under direct threat. Since doctors would have to terminate a viable fetus, the court rejected the plea to exercise its extraordinary powers. The judgment falls short of bestowing any explicit rights to the unborn, but the upshot is that when a fetus becomes viable and is capable of surviving outside the mother's uterus, the woman's right to choose stands extinguished, barring circumstances where the specific conditions outlined in the MTP Act are met. The judgment suffers from at least two errors. The first stems from the court's failure to ask itself what ought to be seen as central questions to resolving the dispute. Does a fetus enjoy an autonomous moral status? Does it have legal standing? Is it capable of exercising constitutional rights? The judgment does not engage with these questions and places the rights of a fetus at a pedestal, above that of the rights of a pregnant woman to her privacy and dignity. The court failed to examine whether the MTP Act is merely an enabling legislation. If the right to freely make reproductive choices is fundamental, the court should not feel injuncted from issuing directions beyond the MTP Act's remit. The petitioner, a 27-year-old married woman, sought her pregnancy terminated due to lactational amenorrhea and postpartum depression. The court ruled in her favor, but the union government asked for clarification on whether the termination could go ahead given the viable status of the fetus. A new report from the medical board confirmed that the fetus was viable and had no abnormalities, and that the medication the petitioner was on would not endanger the pregnancy. The court now ruled that its earlier order had to be recalled, running athwart the court's recent jurisprudence on the fundamental rights to privacy and dignity. In X versus the Guft of Delhi, the Indian Supreme Court ruled that the right to privacy, implicit in Article 21 of the Constitution, allows individuals to exercise autonomy over their body and mind, and allows women complete freedom to make reproductive choices. The judgment found that a woman's right to make reproductive choices without undue interference from the state sprang out of the very idea of human dignity. The MTP Act must be seen as an enabling legislation, not as a law that confers a liberty as much as a law that seeks to provide a means to enforcing a fundamental right. If the statute's mandate is found inadequate by a court of law, it would only be imperative that directions are issued to further the exercise of a woman's right to choose. However, the ruling in X versus Union of India fails to do this. The judgment's implicit assertion that fetuses have constitutional rights is even more damaging. Our jurisprudence on abortion has been built on a converse premise. The guarantees of Articles 14 and 21 of the Constitution, the rights to equal protection and life, are conferred on persons, and the Constitution decidedly does not award personhood to a fetus. Even the MTP Act makes no such assertion, as it cannot create an exception from the timelines it stipulates to cases where a pregnant woman's life is under immediate and direct threat. The next article is Virtues of Planning. Blueprint to develop India by 2047 must factor in critical governance reforms. In this article, the writer says that in early 2024, Prime Minister Narendra Modi is expected to unveil a roadmap to transform India into a developed nation with a $30 trillion economy by the time it completes 100 years of independence. The Vision India at 2047 plan, which has been in the works for nearly 2 years, will be run by the NITI Aayog and will be reviewed by various sectors, including World Bank President Ajay Banga, Apple CEO Tim Cook, Indian industrialists and thought leaders. The plan may be seen as the government's policy playbook promise for prospective voters. However, future governments must maintain an earnest outlook towards the broad agenda. India's rise from 1.1% of global economic output in 1991 to 3.5% now mandates it as the world's fifth largest economy. The final plan should have ideas to help navigate these challenging reforms and ensure policy certainty for global investors. Minimizing the government's role to that of an enabler rather than a macro manager is critical, especially as recent decisions have harked back to past habits like production-linked incentives, import licensing, or overtly zealous taxation. The vision document should split its action points and outcome goals into two periods, 2030 and the 17-year period from then to 2047. Aiming for a high 9% growth rate between 2030 and 2047 is commendable, but factoring in alternative scenarios and changing course when warranted is also advisable. The next article is from Business Standard newspaper, and the article is India's Research Riddle. In this article, the writer says that India has achieved a remarkable feat by landing on the moon on a shoestring budget, becoming only the fourth country in the world to do so. This success is attributed to India's limited spending on research and development (R&D), which has declined since 2008 to 0.65% of GDP. In comparison, China spends around 2.1% of its GDP on R&D, the US around 2.8%, Germany and Japan spend over 3% of GDP on R&D, and Israel an amazing 5% of its GDP. The world average is around 2.2% of GDP. India's R&D spending peaked at around 0.8% of gross domestic product (GDP) in 2008 and has declined since then to 0.65% of GDP. In comparison, China spends around 2.1% of its GDP on R&D, the US around 2.8%. Germany and Japan spend over 3% of GDP on R&D, and Israel an amazing 5% of its GDP. While it is true that a developing country spends less on R&D as it can bring in new technologies from richer countries to catch up, even to do that, some level of R&D is needed. When India underwent a green revolution, it was able to bring in high-yielding seed varieties developed elsewhere because it had its own R&D infrastructure to adapt these to Indian conditions. In pharma, India was successful because it had sufficient R&D capabilities to reverse engineer pharmaceuticals and produce generics. A large share of India's R&D goes to health, 18%, agriculture, 13%, space, 9%, and defense, 17%, with less than 10% going to industrial production and technology and to transport and telecommunications each. India's private sector R&D budget needs to be much higher, as the private sector return to R&D is lower than social returns due to the difficulty of protecting knowledge. Nicholas Bloom at Stanford University has looked at factors that explain why private firms underinvest in R&D, because they cannot capture all the benefits. He argues that reducing the cost of R&D by 10% increases R&D spend by 10%. This can be done by a variety of tax and other incentives, but how these are designed makes a difference. In India, a handful of institutions get the bulk of the government's spending budget, with very little going to universities. More spending on STEM, science, technology, engineering, and mathematics makes a difference, as well as making R&D grants to universities rather than spending it on a few government institutions. India's production of peer-reviewed research papers and patents has increased over time, but India remains well behind the US and China. The way forward is to create well-designed incentives for private sector R&D spending and draw in large and growing universities and institutes into the R&D ecosystem instead of having a few islands of R&D with very little spillovers. Instead of taxing private companies 2% of net profits to do more CSR, it would help focus the energy of the private sector on more R&D. The next article is from the Hindustan Times, and the article is "Law Doesn't Bar States from Counting Castes." In this article, the writer says that the Bihar Caste Survey has revealed the ground realities of the social fabric in India, with different political parties having divergent views on it. The Supreme Court (SC) issued notice on the Patna High Court judgment that held the state government is competent to undertake this exercise. The last available data on caste is of undivided India from 1931, and it has lost its meaning in the present times due to changed circumstances. The caste factor is like communal politics, which everyone condemns in public, but a large number of them indulge in privately and publicly. The discussion on caste is relevant because it exposes different facets of prevalent socio-economic inequalities. As revealed in the Bihar survey, if 63% of the population is backward and extremely backward, the upper caste social morality needs to acknowledge this problem. The middle class in India has grown in the last 3 to 4 decades, cannot be a ground to oppose this process. Insights from accurate caste data can go a long way in addressing the prevailing inequalities in society and filling in the gaps in policy making. The challenge in courts to the caste census has been on 2 grounds. 1, such data violates the right to privacy of citizens, and 2, the state government is incompetent to undertake the process because the Constitution of India gives lawmaking power on census exclusively to the union government. Both arguments are flawed. The concurrent list of the Constitution has entries such as doing inquiries and surveys concerning economic and social planning, social security, employment, unemployment, and statistics of births and deaths. The Census Act of 1948 has neither been defined in the Constitution nor the Census Act of 1948, but it has been understood as the official counting of people of a state or the nation. The center's affidavit in response to this challenge against the Bihar government's caste survey pending in the SSC does not mention its stand on the subjective concept of the right to privacy. It has avoided explaining its scope of powers under Entry No. 69 and has plainly stated that census is covered under the entry. The relationship between caste and social hierarchy is complex, as caste status may change as economic and legal regimes evolve. The cure for the hierarchy concerning castes lies in addressing the economic inequities, and once the data is available, policy making can focus on achieving lasting peace and harmony by ensuring socio-economic justice to all classes and groups.